Mr. Santana, your client, shot a firearm into a human being's chest. And I've got pictures that are alleged to have been from him of posting guns in a tether.
He's locked in the house 24/7. Not a day. Give the court an update. I checked that Instagram account just to see what sister counsel was saying, if it's not his account or anything. Upon checking it, there's actually new information. I have supplied this to sister counsel. And I can show the court. It's actually a footage of another picture with Mr. Santana holding two guns. You can see his GPS tether. You can see his cross neck tattoo. Not his face, but you can see that identifying unique tattoo. And another post, it has and these are 24-hour stories. They're only lasting 24 hours and then they're erased. Another one is a timer, a countdown to court today. The timer has gone off, meaning he's in court today. Another picture of like a picture taken.
Pause right here, because this is where a routine bond discussion turns explosive. The court is seeing isn't just social media posts, it's a timeline, a countdown to court, the exact outfit, the same shoes. In bond hearings, judges don't need proof beyond a reasonable doubt. They're looking for credibility. And right now, every detail is stacking against the defense. Ask yourself, coincidence or digital fingerprints?
A person of their outfit, and you can tell this person's wearing a black suit with very unique shoes that I must put on the record. They're black, like Converse type sneakers with silver spikes on the tip and some red. You can see them very clearly in the image. They are also the shoes that Mr. Santana is wearing right now. And you can see the picture that he took, it matches the carpet in the back. And I think that is enough.
Picture in the courtroom?
I think so. I'm not
Judge,
100%, but it is similar to
all right.
That
All right, well, we're ready to proceed to the hearing.
needs to be displayed.
All right, can you get them up on the screen?
Let me.
All right, okay.
And Judge, just as a heads up, my client about 3 years ago offered to testify on behalf of the prosecutor's office against individuals. He did testify. He now believes that they are doing this to go after him, to cause trouble for him. And his mother, who is present in the courtroom, took his phone back in July of 2025. He has no access to phone. He's on house arrest as well as GPS tether.
All right, let's see the videos.
So he can't.
I mean, someone's not gonna be able to make that up though, miss. Now, if everything she's telling me is accurate.
We'll see, Judge.
All right, we'll see, let's look.
And I must say, sister counsel indicated that he does not have a phone and that he hasn't done anything, but he was in my office and he made a comment. I sent these pictures to a group chat, indicating he does have access to some phone or a computer or something that can send out pictures.
All right, let me see what we have.
This is the one and only image posted on this Instagram account on April 4th.
This is not a bond violation because he wasn't on bond. I got it. All right.
And that Instagram account, and all of his accounts have been closed by his mother.
Doesn't look like it.
With respect to this photograph, which I showed to his family, they're claiming that he took this at his mother's, I'm assuming, come home and says. My client and his mother said this is not her residence. They didn't take this picture. He didn't take this picture. He doesn't know who that is with respect to the tether and the gun.
All right.
Thousands of people have tethers and guns.
All right, hold on. Next.
And you're saying this is posted today?
This is posted today.
Even though he's here today? And
Miss Young.
It's posted 18 hours ago.
that
Okay.
indicates somebody else is doing this to set him up.
Okay, so
Your Honor, my client has on black, stand up, sir, has on black pants, black, step around so the judge can see.
And some
Black
shoes.
shoes, those are not,
those are the exact same
Miss
shoes.
Young,
This-
Miss Young, if you're gonna tell me these shoes are not his shoes, I've only seen shoes that look like that 2 times in my life. One's on the picture and one's on his feet.
Your Honor, I'm telling you to look at the color of the pants here. And this
They're black.
It's a tie that's easily
This is
removed.
not black, that's brown.
That's black.
That is not black.
That's black with light hitting it.
It is not black. My client, as I indicated, did not, his Instagram accounts, all of his accounts have been closed by his mother. She's willing to testify.
So someone, okay, but here's the argument. Just listen, because this is what you're asking me to believe. Someone else made a pretend account of Mr. Santana, and on the, everyone's nodding their head. I'm about to tell you it's ridiculous, but okay, just calm down in the back. So someone creates a fake Instagram. If you have a problem with it, you can go in the hallway.
Yeah, if you're gonna continue to say anything.
Hey, go in the hallway if you have a problem. If not, let me conduct my business. You're asking me to believe that someone made a pretend video. On the pretend videos that they're assigning to your client on an account that he's previously posted on in April. You're asking me to believe that a picture of a floor, a porch, it looks like a deck, of someone showing a tether and a gun is not him. And then someone doing a court countdown is not him. And then someone literally posting a video of them going to court with the outfit on that your client's wearing is not him.
Somebody's trying to set him up to harm him and to make his life worse than what it already is.
Did someone get in?
This is the moment the defense theory starts to collapse. The judge is applying what's called a common sense credibility test. Not forensic certainty, just logic. Same shoes, same tether, same court day, same account history. For a bond violation, the legal standard is preponderance of the evidence, basically more likely than not. And from the bench's perspective, the odds of an elaborate setup are shrinking by the second.
An identical pair of shoes to his and that outfit. And no, Miss Young, I'm asking you a question. Is it your representation to the court that you believe someone else went and got those shoes and a tether and took a picture of it, looking like don't cry, looking like he was going to court in that outfit? Is that what you're, yes or no? Is that your representation to this court?
With respect to the picture, that is not a photograph that he took today and posted it on Instagram.
And he's charged with an offense, a life offense for shooting someone. That's the allegation. And I've got pictures that are alleged to have been from him of posting guns and a tether. The bond's being modified to $500,000 cash or surety. I am not going to let him out into the community.
He's locked in the house 24/7. He's not a danger.
This is 251799FY, the state of Michigan versus Julian Santana.
Good morning, Your Honor. Donna Soap on behalf of the people, P87439.
Morning, Your Honor. Good morning to the staff. My name is Ted Wallace, and I represent Mr. Santana, who is present by Zoom from the juvenile detention, the Wayne County Juvenile Detention Center. Mr. Santana, please state your name for the record.
Julian Santana.
All right, so Mr. Walsh, you requested a motion hearing date on bond.
Yes, Your Honor. It's my understanding that Mr. Santana was out on a bond and made a very poor decision and posted pictures on social media with himself and some firearms, or at least replica firearms, if at the very least replica firearms. I'm not my argument is not that they were real or fake, but that the pictures were posted and that it was a violation of his bond. However, I'd like to point out the fact that he didn't violate his tether. He didn't assault anybody. He didn't fail to appear. No curfews. Mr. Santana is 17 years old, and the law does provide for young people in a different way than they do for adults. They realize that they make stupid decisions. They have, and that's reflected in sentencing, and even in the way that they the amount of time can be detained.
Can I ask this real quick? Because I want to make sure my memory serves me correct. Ms. Soap, is the allegation that Mr. Santana was the one who shot the firearm?
Correct, Your Honor.
Okay, so Mr. Wallace, I feel bad for you this morning. So, and I understand Mr. Santana is a minor. So I had in front of me an allegation that multiple individuals were at a location, something went south, and the allegation is that Mr. Santana, your client, shot a firearm into a human being's chest, and that person was in serious condition, at least at some point. I did the swearing on this. So someone shot in the chest, I believe at, when I say close range, under 20 feet is the allegation. And this was during, or the allegation is it was surrounding some sort of, you know, rowdy group of individuals, co-defendants, maybe shaking people down or causing trouble in the parking lot of this bar. Maybe even committing, I thought that there was something about robberies in there.
That's correct.
So committing thefts under force of violence. And then somehow this ends up with an allegation that your client shot a man in the chest. So that's where we're starting from. So when I originally set his bond, and I just want to make a record so everything's clear. When I originally set his bond on this, I set a very high cash bond because that is appropriate on allegations like this. And then the parties came in. All right, so the original bond was $100,000. Where's the bond modified? Oh, they posted the $100,000.
Correct, Your Honor. And then
All right,
he was found,
I remember that. I remember all that. So the bond was posted, they post the $100,000 or cash or surety form of bond. But I know that there was a motion at some point for the remaining defendants to have a bond reduction. Is that correct? Do you recall that?
I don't recall that. He had a violation of probation for the guns, and then you did not forfeit that.
Correct. Okay, so
Original
I'm
bond, but
getting
you
there.
increased it to, I believe, 500,000.
Got it. So then, so they post the $100,000 cash or surety. At one of the hearings in this court, I can't recall if it was just a probable cause conference, if it was a bond violation hearing, Madam Prosecutor brings up accounts that are associated with your client, at least to the standard needed for a bond violation hearing. One of the photos shows someone from the neck down wearing the exact same outfit your client wore to court that very day with some very distinct tennis shoes, saying, you know, on my way to court, clock's ticking, something along a countdown. So, I mean, there was pretty clear evidence, in my opinion, to a preponderance of the evidence standard that your client was the one in control of this count, because there were selfies of his exact outfit that he wore on that day to court. There were also photos that were posted that were only considered to make a determination as to whether or not that account was your client's account. And there were photos of his neck tattoo. I believe it's a spider. I'm going off of recollection, or a cross, or it was something large on his neck. So it was clear that the account, both before the really relevant photos and after the really relevant photos, that this was an account run by your client. Then in the middle of all of it, I have got someone who is again alleged to have shot a man in the chest. And there are photos of him sitting on a deck with a leg, which his prior attorney said wasn't his leg. But I am not the stupidest person in Wayne County. And the picture shows a tether on his leg and a handgun, a gun in his hand. It's a picture of his tether and his foot and his gun, or a gun in his possession, that he's posting pictures of on social media. So one of the bond conditions is I've got a guy charged with assault with intent to murder for shooting someone in the chest, and he's posting pictures of a firearm and his tether, making a mockery of not only this court's order, but the law. And for somebody like that, Mr. Wallace, absent an absolute miracle, and I'm making this record clear so you can send it wherever you need to send it, absent an absolute miracle, there is not a chance that I am changing Mr. Santana's bond. Mr. Santana flouted my court order, and he didn't just do it,
This right here is the emotional and legal breaking point. The judge isn't reacting to teenage mistakes, missed curfews, failed tests. Those are expected. What crossed the line was mockery. Posting a firearm while on bond for a shooting offense with the tether visible sends a message the court cannot ignore. This isn't just about one defendant anymore. It's about public safety, respect for the court, and consequences that echo far beyond this case.
he would have been out past his curfew, or even if he would have tested positive for marijuana, those are violations that I could expect from someone of his age that I think are, fairly standard violations. But for somebody on bond for a weapons offense that is a life offense, to post pictures on, and there were others, but that one in particular, for him to post pictures of himself holding a firearm and having the audacity to put his tether in the picture that I ordered as one of his bond conditions is absolutely outrageous. And I can't think of a judge in this great state that would disagree with me on that. And Mr. Santana, I understand your age. You made a decision. When I'm considering bonds or bond modifications, I have two duties. The first is to make sure you show up to court. And I have no indication or reason to believe that you wouldn't show to court. The second is to protect the community. And the idea that I would let someone out, I don't care who your lawyer is. Mr. Wallace is a very talented attorney, but the idea that I would let someone out or consider a bond modification when you had the most egregious violation other than killing somebody or shooting another gun at somebody, I can't think of a more egregious violation, a flaunting of my order, and your complete disrespect for the court, disrespect for public safety. And there's just absolutely no way that I would modify this bond under these circumstances. There is nothing special about Mr. Santana. Mr. Santana made a choice, and that choice had heavy consequences. And I left him in the care of his mother. And quite frankly, Mr. Wallace, instead of forfeiting that money that could have affected their housing, I have no idea where the money came from. I did not forfeit that bond because I thought that was the decent thing to do, because his parents ultimately shouldn't lose their home because their son makes bad choices. But I've made my record. I respect your argument. I understand you're doing a job, Mr. Wallace, but there is absolutely no way I'm modifying Mr. Santana's bond.
Okay, thank you, Your Honor.
All right.